Court order to produce Nnamdi Kanu for appeal record settlement. Before we proceed to the rest of the news, you are welcome to AZI Base Info. Please kindly subscribe and turn on your notification bell. Here we drop latest happen news, politics and entertainment. The lawyer expressed shock that despite issuing the summons, the court declined to grant the production warrant, a mandatory order that authorizes prison authorities to convey an inmate from detention to the courtroom. Barrister Aloy Ejimakor, special counsel to the detained leader of the Indigenous People of Biafra, IPOB, Nnamdi Kanu, has raised an alarm over the refusal of a federal high court in Abuja to issue a production warrant needed to ensure Kanu's presence in court for the settlement of records in an appeal the IPOB leader filed before he was convicted and sentenced to life imprisonment. Kanu was sentenced on November 20, 2025. Ejimakor raised the alarm on Wednesday in a post on his X, formerly Twitter, account, where he attached a copy of the court summons requiring Kanu's appearance. According to him, the summons scheduled Kanu to appear before the Federal High Court on November 28 for the settlement of records relating to an appeal he filed prior to the court judgment delivered on November 20. He wrote, "This is a summons to Mazi Nnamdi Kanu to be present on November 28 at Federal High Court in Abuja for settlement of record for the appeal he filed before the November 20 judgment. A production warrant is required for the Sokoto Prison to bring him to Abuja, but the court refused to issue it." The lawyer expressed shock that despite issuing the summons, the court declined to grant the production warrant, a mandatory order that authorizes prison authorities to convey an inmate from detention to the courtroom. Kanu. Without it, Ejimakor warned, Kanu cannot be physically present for the court proceedings, potentially undermining his right to a fair hearing and due process. Ejimakor had raised concerns that transferring Kanu to a correctional facility in Sokoto, hundreds of kilometers from Abuja, posed a serious threat to his right and ability to file and pursue an appeal in his case. Speaking on Channels Television's Morning Brief program on Monday, November 24, Ejimakor warned that Kanu's constitutional rights under Section 36 of the 1999 Constitution of the Federal Republic of Nigeria were now at risk. Ejimakor stressed that the appeal process required immediate and detailed actions that were impossible to execute without close access to the relevant courts and legal support. Ejimakor said the legal community and observers were stunned to learn that Kanu was moved from Abuja to a prison in Sokoto shortly after his sentencing. He questioned how Kanu could meet the strict procedural demands required to initiate an appeal. Ejimakor argued that several facilities he shared with Abuja, such as the leader instructed him to relay his concerns about the judgment, legal assistance and surrounding his transfer. He warned that Kanu's ability to pursue an appeal was conviction was without legal basis of his imprisonment, arguing that no court can lawfully convict an individual on 7 terrorism-related counts on Thursday, November 20, 2025, by his final written address which anchored on fair hearing was also denied years of trial disruptions. He emphasized that the evidence relied upon by the court was not included in the Nigerian sheet or presented as evidence against before his conviction and sentencing. Additionally, Kanu was held reliance on struck-out charges from Justice Vincent Nyoko was a significant issue, 2021, after his controversial arrest and extradition upon reviewing the judgment from prison, identified what he described criticized by local and international human rights undermined the entire trial. In October 2022, he said the Court of Appeal discharged Nigerian charges and ruled that his extraordinary lawyers to carefully examine the judgment and uphold the laws of the Nigerian government and appealed the decision, securing a stay of execution. Kanu was also said to have questioned why favorable
Amen. Sorry?